These guys will not give you due process because they're so used to going through people like sheep and cattle, they don't have to obey the law because no one ever calls them on the law. And your failure to object timely is fatal. And failure to assert a right waives the right. Right? You understand that? Alright, so you'll notice here in this little bundle then, I label these 1, 1A, 1B, 1C, 1D, and 1E. Alright? Well, let's see, what did I get here? I got a complaint dated 8/9/82, and it's number D, isn't it? Well, let me take a look and see what I got here. Oh, yeah, here we are, criminal complaint. Looks like some guy named Tim Gass signed this, and he charged that the said defendant, George Gordon, on or about the 9th day of April, 1982, in the county of Ada, state of Idaho, did maliciously injure certain personal property, to wit, a pair of coveralls, the property of Ada County, by taking overalls apart at the seams. Oh, I thought that was funny. Willfully and maliciously. All right. Well, the next question that comes up, and remember, I'm only talking about not the merits of the case, but the process by which we go through. I've got a complaint, haven't I? All right? Now, I want you to notice something here. There's 2 cases here. Remember, originally I'm charged with a felony. That was dismissed. That file folder was also this thick. And when that was dismissed by Judge Smith, there's victory number 1. All right? Now they come back and charge me with a misdemeanor. Okay? Same thing. Look at the size of that file folder. All right? Now, this one was dismissed. There's victory number 2. In the process, I've kept the entire record. And the reason for keeping this record is to show the willful, malicious prosecution on the part of the prosecutors of this county. Not the judges, because remember, the judges aren't involved in this. The judges dismissed this foolishness. But it was the prosecutors who brought these foolish charges against me. And let me tell you, it's extremely difficult, friend, to prove malicious prosecution and abuse of power. What you need to do is to keep these file folders in order, carefully, meticulously, so that 5 years, well, not 5 years, but a year from now, when you want to bring 5 or 6 of these cases, by the time you've got about 6 or 8 dismissals, you've established a long train of abuses, of willful and malicious prosecutions. I think I've already established that. I'm up around 20 right now, and of course I was in court today, and it was humorous when the judge says, but there are no convictions. All that shows is that the king and the king's agents are out here busily arresting George Gordon and throwing him in jail and compelling him into the courts of Idaho to defend himself against false and malicious charges constantly. That's all that shows. And that's the kind of evidence that I want to use when I go into the federal district court and charge them with malicious prosecution, false arrest, false imprisonment, abuse of power, and malicious abuse of power. And I can do that because I've got all of my paperwork in order. See how that works? You must train yourself to keep your paperwork and to keep it in order and to keep things written down. All right, now, I take a file folder. This is a legal size file folder, and you want to keep in mind that in the federal courts they've moved now down to the 8.5 by 11 size paper, so it's regular letter size paper. In this state, in our state courts, I'm still using this legal size paper. So you need to get your file folder, and up here you write on the flap, right up there, it says malicious injury to property. Write that on there. Then did you notice over here in this corner, let me get this centered. Zoom in on this, would you, Ted? You notice over here, there's a date on there, and it says September 27th, 82, 2:30 Willis. All right? What I've just done there is, here's the date, time and place set certain for the trial or the next hearing. You must always establish a record of never missing your hearings and your appointments. I had a judge tell me not long ago in casual conversation that it would be difficult for any judge in the state of Idaho to set bail on me. I always make my appearances, and that's extremely important to each and every one of you, because, you know, if your government's going to get after you like they do me, and they're going to bring you in on 7, 8, 10 charges, you could be out tens of thousands of dollars trying to post all of the bails and the bonds that are going to be required, or a lot of $100 bills in that 15% bail bond. And you want to avoid that like the plague. Make your appearances. You should be a tiger, not a mouse, hiding in the corner. But, you know, you want to be a lion. Lions don't hide. It's mice who hide from their government. All right, so there you've got your file folder. And now you've got your time and place. And then every time there is a new date, time, and place set certain, I'll write down whatever that date, time, and place is for whatever hearing it's going to be. And then I keep a calendar. And when you get busy like I am, you'll need a calendar so that you can immediately write that down. And then every morning when you come in your office, you can say, oh, I can see tomorrow I've got a motion hearing. I can see I go to trial on this day. I can see that I've got an evidentiary hearing over here. I've got an arraignment over here on this day. And keep those straight and keep after them. All right, now, I want to go on through here because I want to show you some of the caliber of the motions and arguments that we put in. And number 2, you'll notice I put down Idaho Code 193506, which is the effect of dismissal at bar. Now, in this state, that is the particular statute that says you can't bring a misdemeanor twice, or when it's a felony and reduced to a misdemeanor, you'd invoke that statute and then move the court to dismiss. Number 3, you have a notice of trial. Well, now let's take a look and see. When is trial in this particular case? Number 1, number 2. Here we go. Number 3. Here's my notice of trial. All right. Number 4, notice and demand for counsel of choice. You see, that came in pretty early, didn't it, in this case? And you make that demand each and every time that you appear in court. The motions for your, what we call standard, everyday, garden variety rights are right sua sponte, jury, public prosecutors, counsel. I could go on and on. Jurisdiction, status. You know, here's jurisdiction. Number 8, notice and demand. Follow along here, would you? Number 8, notice and demand for dismissal for lack of jurisdiction. That's a motion for dismissal, and then there's 6 briefs in support of that motion. My contention here in this case was that this court had no jurisdiction in the matter because the case had already been brought once as a felony and then reduced to a misdemeanor. I'm saying, well, now it has the effect of a dismissal at bar because the statute prohibits the state from bringing this action again. So you see, the court has no jurisdiction. Now, the court did not dismiss this matter as a matter of jurisdiction. They dismissed it as a matter of a violation of the statute. That's what the judge did in this case. Going on down, 9, jurisdiction brief, memorandum of law in support of jurisdiction, status to contract. Number 10, another jurisdiction brief, merchant at law in support of demand for dismissal. Number 11, jurisdiction brief, rights in support of demand for dismissal. On computer, we have, and I think that you already have now in your first 3 tapes, in the first 6 lessons, the catalog from our computer. You should subscribe to that computer service. It costs you $10 a month, and you get our newsletter every month. Come on in, Ted, and let's take a look at our computer room. And let's take a look at the facility that we use to send out information all over the United States. We're now using 2 Apple II computers with a printer. And I don't know how many of these discs we have over here, but there's probably 50 discs that are just crammed full of information and briefs and motions and the type of legal information that each and every one of you need. As you can see here, Bob Hallstrom is now typing in the necessary information at the top of what we call the heading on a brief or a motion. 50% of the case is going to be determined for you by the paper that you submit. And whether you're in Texas or California or what state you happen to be in, there's a judicial district and the minimum necessary information that you need. As a computer subscriber, your name is put on a computer disk. In other words, you'll have a disk here with your name on it and with your information on it. And this information then, from whatever part of the country you're from, when you call in and say, I need a particular motion, let's get a motion for council, let's say. Then we can type that pertinent information from wherever you're located into the computer and pull up the motions that you select off of the catalog and send those to you for only 15 cents a page. In our state, they charge us $2 a page up here at our local courthouse. And we can do this for only 15 cents. Bob, print a page and let's see what we get for a customer in Texas.
There you go, George. I made this up with my name on it rather than somebody else's, just to simplify it. And that's a simple affidavit of status.
Zero in on that, Ted. There's the original ready for filing. An affidavit of status, name and address, got the heading. And if you'll notice down in the bottom, there's your notary public seal ready to be notarized and filed. Can you zero in on that? All right? Now, let me show you what else we can do. These discs can be sent to you, and if you have the means or the capacity for using this disc in your computer or of transcribing the data from this disc to another disc, we can make these discs available for you, and there's something like 120K on each one of them. And every one of these discs is filled with information at such a price, or such a low price, I should say, that you couldn't afford to even begin to put a typist to sitting down here at one of these keyboards and putting this kind of information into your own computer or typing it out. Now, if you'll remember, I think I told you a little earlier that in the early days when we filed 10 or 15 motions, boy, I mean that was a major case for us 5 years ago. Today, I would say that every traffic ticket that goes into a court in Ada County, Idaho, has 30 motions and briefs with upwards of 200 pages in each one of those files. And all of that material has to be answered by the county prosecutor or the city prosecutor. And when that prosecutor fails to answer, then it becomes reversible error. So what we're talking about here is then not papering the court with frivolous or meaningless data, but rather putting in the arguments that each and every citizen is entitled to have before the courts for an adjudication of his issues pursuant to rights, and to be argued clear to the U.S. Supreme Court in Washington, D.C. Now, I wanted to take you into our computer room so that I could show you, no matter where you are, whether you want the discs or the tapes or not, what we've discovered here as the secret, or is the secret for us, to winning so consistently in the courtroom. And that is that we go in prepared. Our students are trained to go in. And when we go in to win. We don't play the game half-heartedly. And we're there with serious, meaningful constitutional issues that we want to argue clear to the U.S. Supreme Court. And we find that when we get to the district court or to our state Supreme Court, they don't want issues like, do blacks ride the back of the bus leaving the state of Idaho? Because many of these laws in the state are revenue makers. And our Idaho State Bar does not want to answer the question about counsel because they want that monopoly for themselves. And that's fine. As long as our state bar wants that monopoly for themselves, they can forget about convicting citizens for anything from parking tickets to murder. Because you can't get a conviction unless you have due process of law. Without due process of law, the issue isn't did you kill the person, it's why didn't you grant that man due process of law. That is the winning issue, and it's called reversible error, forcing the case into a trial de novo. And I want to show you here a parking ticket, and you can't read it because, I can sit right here and look at it, and I can't read it either. But this is a parking ticket from Boise City, 121-492P. Now, the process that you go through in the subject matter of due process is the same whether it's a parking ticket or murder. You're entitled to a complaint with a sworn affidavit, and all of the rules of procedure that go on through the entire process is what is known as or called due process of law. As soon as you get the complaint, whether it's a parking ticket, a citation, a summons, a complaint, an information, or an indictment, the first thing you do is get a file folder. Take the file folder and put the title and name of the action and the case number, which in a parking ticket case is 121-492P. If it's, let's see, what's the case number on this one here? Number 25C-2578, when we were talking about this felony, tearing up your jail clothes or destruction of jail property. And then when it was reduced to a misdemeanor, then the number changed again, and it was called something else. I don't know what it was. I know it was 25C-2578 is a misdemeanor, and when it was a felony, it was something like CR, which was criminal in this state, 10-906, something on that order. So the numbers change, and when those numbers change, the paper that you file has to change and go into the right file folder, because, friends, as the case gets appealed, this file folder with all of the pertinent data goes to the next higher court. And the file folder gets this big, and then this big, and then this big, and then this big. And when it goes to the Federal Supreme Court, let me show you this one. It'll boggle your mind. When this case goes to the Federal Supreme Court, it'll be this thick. And they want 40 copies. That's right, friend, not 4, but 40 copies of this goes to Washington. That's so that the law secretaries and the justices will all have a copy. Right here in our own state Supreme Court, when we get an appeal going to our state Supreme Court, we have to have 9 copies. That's 6 for the Supreme Court itself, 1 for the Attorney General, 1 for the District Court, and of course 1 for us, and there's 1 for the prosecuting attorney or the past judge. I forget how it goes, but anyway, it takes 9 copies. You don't have to file copies of the case itself. That's moved up of and by itself. But do you see the cost that's involved for your government when they want to go argue this case to Washington? Because everything that you've done, they have to do. And it costs about $60,000 now to argue a case to the Supreme Court in Washington. That's generally expected to cost $60,000 for the state and $60,000 for the defendant. But wait a minute, friend, you're a competent pro se, and all you're in the case is your time, effort, and energy. And I don't know what your time, effort, and energy is worth. You know, if you're out there and you're an oil magnate, maybe your time is worth $10,000 an hour and you can't afford to mess around with this sort of thing. Well, in that case, then forget it. But if, on the other hand, your freedom and your independence means something to you and you don't want to carry a driver's license and bound scrape to your government, well, then maybe that is pretty important. I'm estimating that my time, effort, and energy, and of course I do this full time, is probably worth a couple of $100 on each case. And here's the way I see this. That ticket right there is extortion. And whenever somebody puts one of these extortion letters under my windshield wiper, I figure that anything that's important enough for my government to prosecute is important enough for me to defend. And if it costs my government $1,500 for a trial, then it wasn't George Gordon that brought the trial into the courtroom. It was the government. And I think part of our problem with our government is these people have too many people on the staff and too big a budget, and they don't have anything for those people to do, and so they have to prosecute people like George Gordon with parking tickets so that they can spend all that taxpayer money. Now, that's the way I see that, and if that's wrong, well, then why don't you correct me? There's your parking ticket. There's your file folder. There's your number. There's your hearing date. Now you've started the process that's going to end up like this with a dismissed over here on the right-hand side. And that's what I like. I have a whole file cabinet full of cases that have been dismissed. Never won a case in front of a jury. I have high hopes that someday I may learn how to do that. Now let's take a look at the next thing, and that's the subpoena. Whenever the government hauls you into court in the state of Idaho, and of course the rules will change, and it's up to you to check with the rules in your state, but in Idaho you get up to 5 subpoenas or 5 witnesses. Zero in on this subpoena, and let's see if we can read this. Now I'm sending this subpoena along with you in this file folder with this lesson so that you can have an idea of what these documents look like. They may be a little different in the state where you're from, but essentially they're going to be the same. There are civil and criminal subpoenas. So here are 2 subpoenas, one civil and one criminal. Let's take a look at the process, first of all, before we look at filling in the blanks. If you'll notice, if you need 15 witnesses, then you should subpoena 15 witnesses. And of course, every time you have a confrontation with your government, you want to make sure that you go out and identify all the witnesses that are there. It doesn't make any difference. It could be passers-by in the street. What have you seen? What have you heard? And what do you know? You may use them or you may not. But always be alert to identifying witnesses. The store clerks, the truck driver, the delivery boy, whoever it might be, whoever saw whatever it was that you want them to testify to. Now, a subpoena is a unique document, and it's a court order for that person to appear in court in your behalf. But serving the subpoena can be another problem. And I want to talk to you about that subpoena and serving that subpoena, because it's a part of this thing called service of process. You're entitled to service of process, but so is the prosecutor, and so are all of the witnesses. So here in Idaho, you have what's called 5 free subpoenas. Over 5, there's a statute in the state that requires you to get the judge's permission. So let's zero in on this one, and let me show you a subpoena that was rejected because we didn't have the judge's subpoena. We didn't have his permission. So zero in on this one, and here's one that's filled out. Okay? Now, if you'll notice, I want you to follow along with me on this one. I'm going to read it as we go along so that you can see how this thing is filled out and why it's filled out that way and what the subject matter is. Here we see that up in the upper left-hand corner it says attorney, address, and telephone. Well, that's me. I'm the attorney in propria persona. My name is George Gordon, 1205 North Roosevelt Street, Boise, Idaho, 83706, and my phone number's on there. Going on down, it's in the District Court of the 4th Judicial District of the State of Idaho in for the County of Ada. And you'll notice the caption is the State of Idaho Plaintiff versus George Gordon Defendant. And you can see where I've filled in those blanks. Now, in your state, there may be some other form, but it's simply a matter of filling in the blanks. Case number 35C 238, and you'll notice it says subpoena criminal. Now, there's a big difference between civil and criminal. So we're talking about criminal subpoenas right now. Remember, you just gotten the ticket, and the policeman who gave you the ticket arrested you and took you to jail, and as a matter of fact, out there at the scene of the crime, or whatever it may be that you want these people to testify to, you need these people in the court. And don't ever leave it to just, well, would you come in and testify, Joe? Yeah, it's at 9 o'clock next Friday, and thanks a lot, I'd really appreciate it, because, friends, I don't care if it's your mother-in-law, she won't be there. Not unless you give her transportation and buy her breakfast. She won't be there at 9 o'clock. And so each and every party, I don't care who it is, I don't care if it's my wife, I've got subpoenas out subpoenaing my wife and my oldest boy into the court. And in addition, when you subpoena them in, then the county has to pay the subpoena fee. And in this state, I think it's $8 and plus mileage. So you might as well have your oldest boy and your wife get a little mileage in a subpoena fee. Now, it says to whom it is addressed. And in this case, it says to Darla Williamson. And it says where you are to appear. You are commanded to appear before the District Court, 514 West Jefferson Street of the 4th Judicial District in and for the County of Ada, at the courtroom in the courthouse in Boise, Idaho, in said county, on the 7th day of March 1983 at 9 a.m. as a witness in a criminal action prosecuted by the state of Idaho against George Gordon. Now you'll notice at the bottom it says, given under my hand this 7th day of March 1983, and then it'll have a stamp. Now this particular one that you're going to get says refused on it. That's because I subpoenaed over the 5 persons that are allowed by statute free of charge. In other words, there is no reason to go to a judge if you're going to subpoena 5 people or less. So in this case, I subpoenaed 18 people, so pursuant to the statute, and always make sure that you check the rules or check the statutes to see what the minimum number is. And here's where you go. You go to the law library and you look up subpoena under both civil and criminal rules. And it'll tell you all you need to know. Then you go to your state statutes and you look up the word subpoena. And you just take a look. And it'll say something like the number, how many, when they have to be issued by a judge or approved by a judge. Don't get hung out like I did one time. I filed 18 or 20 subpoenas and then found out that some of the people refused to appear because there were over 5 issued. Well, I don't make that mistake anymore. You can avoid that because when you get to the subject matter of subpoena, take an hour and go to the law library and just run over the ground rules for subpoena. And that's the way I do things. See, I'm not concerned about subpoenas when I'm talking about arraignments. When I have an arraignment to go to next week, let's say it's next Thursday, and I've got a week to do it. I'll say, okay, now I've got an arraignment to go to, so I'll go to the law library and I'll take out criminal arraignments and I'll just brush up on it. And I say, okay, did I do this? Did I do that? Did I do 3? Did I do 4? Yeah, I've got all those done. I got my checklist out of the way, so I'm ready for arraignment. Now I go to arraignment, I serve my arraignment and plea, I run over whatever the information is that I need. Now arraignment in that case is behind me, isn't it? What's the next thing that's coming up? Oh, well, let's try a motion hearing. All right, now I go to motions in the criminal rules and I say, okay, now I brush up on motions. Did I do 1? Did I do 2? Did I do 3? Did I do 4? Let's suppose at the motion hearing I want to call some witnesses. Okay, now I got to subpoena these witnesses in. What do? I go to subpoenas, both in the rules and in the statutes, and you simply go to the index. See how simple that is? But don't leave it to your memory, and don't leave it to chance, because you don't know the law, and you don't know the rules. And so you use the Edison formula, and that is, well, I may not know what it is, but I'll go out and I'll find out what the information is that I need to know. And it doesn't take that long. It takes about an hour for each one of these items. Each topic will take you about an hour to research or look into. If you can't do it yourself, then send the wife down to the law library, or send the girlfriend or one of the kids and say, okay, now son, go down to the law library and I want you to Xerox off some copies of the subject matter of subpoenas out of the criminal rules. And that's all it is. You come back and now you can follow those rules. If you don't follow the rules, they will call those rules on you, and I mean they'll make you dot every I and cross every T. They will bring you to the same standards as a lawyer. Check in here under legal quotations. You cannot be held to the same standards as a lawyer. And there's several Supreme Court cases in here that say so. Circle those and note them down, and then when your court says, well, you've come in here pro se, Mr. Gordon, and you will follow all the rules that the lawyers follow. Excuse me, Your Honor, but I'd like to bring your attention to this case of blankety blank versus blankety blank. And I'd like to caution the court that this court cannot hold me to the same standards as an attorney. However, sir, I will do the best I can to conform with all of the rules, and I'll not knowingly violate any of the rules. But should there be an omission, I'd like the court to take judicial notice that I filed a motion for my right sua sponte. And if the court will be so kind as to simply remind me of the rules as they come available and my rights as they come available, I'll be more than happy to obey all of the rules. And that's the way you hang those guys out to dry. So, here's your criminal subpoena. Now let me show you a civil subpoena. Same essential item, no big deal. Here's your civil subpoena. It's simply a matter of filling in the blanks. So just take this and go copy it and fill in the blanks, and it'll say the same thing. Now, you're at home and you've got either a civil or a criminal subpoena filled out, right? How many copies do you need? Okay? You need a copy for the court. You need a copy for yourself. You need the original copy so that when the person appears in court, you give him the original and then he takes it over to the clerk and gets paid. And you need a copy for the prosecutor. So you need 4 copies. So here's what I do. I take the subpoena and I run off and I fill the thing out. Essentially, I fill it out. And then I go copy it, and I make 3 copies. And so now I've got 4 copies here with a paper clip at the top. And here's one witness that I want. Then I take another one, do the same thing. Fill it out, put the man's name in it, everything I need, and then I put a paper clip on it, and there's 2. Let's say you've got 10 witnesses you want to subpoena in. So you take your 10, your little stack of paper, and you go to your court clerk. Now, that's not the judge's clerk. That's the county clerk. If you don't know where to go, just call any lawyer and ask him. Or start asking around. In our state, it's the court clerk. In Ada County, we've got a building which is right across the street from the courthouse, and we walk in there, and there's civil, and then there's criminal, and then there's district court. So it'll take you a little time, and it just takes a little patience to find out where to go. And you take them and say, I'd like to issue these subpoenas. And the clerk will take the top copy, the original, and she'll emboss that. That'll have to be notarized, or it'll have to be certified or subscribed to, and she'll fill that out, and then she'll make copies. In other words, she'll stamp copy, copy, copy on the next 3 copies. Now, if you'll notice on the back, zero in on this so that you can see the return. On a criminal subpoena, there's a return that has to be filled in. Do you see that? Well, I think you can see that. If not, just follow along with me as you take a look at this return, and you'll see that we've got it filled out for you here so that you'll know how to make a return. If not, do a little practice, ask someone. In a criminal subpoena, you can't serve it yourself. It has to be a person who is not interested in the case and who is over the age of 18. So here's what I do. I've gone into the court clerk. She certified the top copy. That's the original. And now I've got 3 copies, and I give it to my friend over here. And he takes them. Here, friend, take these. And he takes them. And he goes out to the party. Now, these guys sometimes will try to duck service of process. Okay? Talk to you in a minute about ducking service of process. But we'll assume for the moment you find the guy. Oh, are you Mrs. Williamson? Mrs. Williamson, this is the original of a subpoena, and just hand her the copy. If she won't take it, let her drop to the floor. Now your friend takes this and he fills in what's called the certificate of service on the original. And if she doesn't show up to court, you give that original to the judge, and then you have her arrested for contempt of court. And that's the way that comes down. And that's the power of the subpoena. The person who doesn't appear in your behalf, and remember, you're entitled to these witnesses in your defense, whether they're friendly or whether they're hostile. And then if they don't show up, then if it was me, I'd say, well, I can't move forward, Your Honor. This witness is necessary and imperative. This witness can testify that I was in another county at the time this alleged crime occurred, and I wasn't even here, and I didn't have anything to do with it. And without this witness, Your Honor, I don't think I can move forward. So therefore, I'll leave it in the court's discretion as to what it would like to do next. Now, if you'll notice here on the back, and follow along with me as we read through, I'm going to fill this out so that you can see how this goes. Now, let's assume that I'm the fellow who's serving your subpoena for you. And if you'll notice, it's the State of Idaho, County of Ada. So I'm going to write in the word Ada. I hereby certify that I served the within subpoena on the 7th day of March, 1983, on, and let's write in the name of the party that we served it on. In this case, we'll call her Darla Williamson. All right. Being the witness named in said subpoena at the county of Ada, by showing the original to the person, that's Darla Williamson, said witness personally and informing her of the contents thereof. Now you'll notice it's dated March 7th, 83, and now I'll sign it. I'm going to sign it George Gordon. It can be signed by whoever it is that served it. Now the party has been served, and now you have the certificate of service. All right? That's all there is to it. Now if you'll notice on this particular one that you have as a sample, it says refused, and the reason it was refused is the judge wouldn't issue this subpoena. Okay? Just that simple. No big deal. And so in order to qualify this witness, I had to fill out an affidavit and say, here's why I need this witness. This witness is necessary and imperative, but the judge said, well, the information that she's going to testify to is in the record, so therefore you don't need it. All right? That being the case, then, I guess I don't need her because the judge says you don't. But what if you get in there and she's not there and you need her? Now you scream reversible error. Judge, I told you that I needed that witness, and you wouldn't issue that subpoena, and here we are stuck. I absolutely needed her, and that's what I thought, and so therefore I move for dismissal. He may or may not dismiss because it may or may not be harmless error. If it's harmless error, they don't have to dismiss. But if it's harmful, if it's prejudicial to you in some way, make sure that you say, this is prejudicial to me because her testimony is necessary and imperative, and these witnesses are going to go back to California, and now without this witness I'm unable to establish where I was that night. And these witnesses are going to leave and go back to California, and they're going to testify that thus and such is true, and therefore this is absolutely prejudicial to me, and I'll never be able to recover from this, and I move for dismissal. Now, if you can establish that, the judge may have to dismiss. And if he doesn't, on appeal, you'll scream that that was prejudicial to you, and the appeals court will dismiss it. Now, if you'll notice here, on the civil subpoena, it doesn't have a return. I like to always put on the back of the subpoena who and when and where it was filed and who served it. So just have the party who is going to serve the subpoena for you write in, I personally served this subpoena on, and then you put the name in here, Joe Baloney. This 7th day of March 1983, and have the guy sign it, whatever his name is. I'll sign it here, George Gordon, all right? And there's 2 copies, and I want you to take those and put those in your files and study and practice a little bit with them, because this is part of the service of process. Failure on your part to carry out service of process denies due process to someone else. And if you deny due process to someone else, you're not entitled to due process yourself. And remember that due process is simply the orderly progression of the judicial function.